Judge, the parties have agreed that they will be joint managing conservators. And I'm going to go through the joint managing conservators as to some of the details. Mother, Miss Rios, has exclusive right to determine primary residence of the child. Ms. Rios has exclusive right to receive child support payments. The parties have right to consent with regards to psychological, education, and medical and dental will be joint rights with tiebreakers. And those tiebreakers for the medical and psychological will be the treating physician. And then for the educational, it's going to be the school counselor, which is going to be the tiebreaker.
Where those people might not be willing to make decisions.
It's going to be, actually, Judge, I think what it's going to say is that the parties agree to follow the recommendations for heads and meds, recommendation of the child's treating physician, and for eds to follow the recommendation of the guidance counselor or school official.
Okay. It just, in my experience, is doctors, I think, I don't know, maybe they're depending on the situation, are sometimes more likely to give a recommendation. Counselors are often like, well, this is possible. It's up to you often. So hopefully they'll be able to work it out.
Oh, and Gary, I think we probably need to put in there that Mr. Navarro is adjudicated as the father of the child, and it's kind of obvious since we're doing it, but probably need to mention that.
Yeah. Judge, to keep going with the conservatorship, mother has exclusive right to enroll child in public school. The parties have right to consent to underage marriage or enlistment in the armed forces. All the other rights will be independent. The geographic is going to be Galveston and contiguous counties. The possession access is going to be the standard possession order. Would start finish at 7 p.m. The passport and travel is going to be standard language regarding passports. Ms. Rios to maintain possession, and then the notice requirements for travel abroad, standard language regarding notice for travel abroad. Judge, the child support, the gross is 6833.54. Health and dental is going to be covered through Mr. Navarro's employer at a cost to him of $52.24. There's one child in this case, one child outside this case in his household, which brings guideline child support for multifamily to $954 a month, which will start August 1st, 2025. Judge, also there's a acknowledgement of paternity attached to our petition, which establishes Mr. Navarro as the father. We ask that you take judicial notice of this AOP.
It acknowledges that this acknowledgement of paternity exists and is valid. Mr. Kennedy?
No objection.
I take judicial notice, and I take notice that everyone agrees it's a valid and AOP.
Judge, anything that that's unreimbursed that the insurance doesn't cover is split out of pocket 50-50, standard language in the family code. And Judge, also the parties do agree that the subtotal for the retro is $15,458.
Subtotal is what number?
$15,458.
Your determination of non-disclosure of address request?
That's not an issue, Judge. No need for a non-disclosure.
Okay.
And Judge, the only issue that the state sees is the credit. And at this time, I call Ms. Rios. Ms. Rios, can you state your name for the record, ma'am?
Fabiola Rios.
Now, Ms. Rios, did you hear and understand the agreements that I read into the record, ma'am?
Yes, sir.
And are you in agreement?
I am.
Okay. Now, I'll come right back to you. The state calls Mr. Navarro. Mr. Navarro, did you hear and understand what I just read into the record?
Yes, sir.
And are you in agreement as to those agreements I read?
Yes, sir.
State recalls Ms. Rios.
Before you do, Mr. Kennedy, do you have any questions about those issues for Ms. Rios or for
I do not, Judge.
Mr. Navarro?
I do not.
You may continue that.
Thank you, Judge. Ms. Rios, now you're asking for retroactive child support from March 1, 2024 to today, July 21, 2025, right?
Correct.
And
I'm sorry, what was the date?
March 1, 2024 to today. And Judge, at this time, I offer State's Exhibit 1, our retro calc sheet.
Mr. Kennedy, do you have any objections?
No objection, Judge.
Ms. Rios, do you have any objection to me admitting State's Exhibit 1?
Oh, no, Your Honor.
Okay, State's Exhibit 1 is admitted.
Now, Ms. Rios, as you know, the subtotal that was calculated is $15,458. Now, what's in dispute is the credit, as we said earlier. How much has Mr. Navarro given you from March 1 to present in the form of child support or some type of support to help with your child?
So according to my calculations and what I considered,
What did you say? Your calculations and what you...
and what we've considered is child support, it was $7,005.
Okay. Now, ma'am, Mr. Navarro claims that he's given you $10,155. Isn't that correct? That's what he claims he's given you.
That's what he's claiming, yes.
Has he given you that much?
So in reference to the Exhibit 1, I don't believe there's money on there that has been sent to me it's considered child support or funds that are sent to me for our son, because I have notated on here specific times where he sent me money for other reasons, for whether it's for food, and this goes back to March. So I have written down and jotted down based off of our messages. In full, the 10,000 is not what he sent me for child support.
So he says that he basically gave you a little over $3,000 extra. Do you dispute that?
Yes, I do dispute that.
So are you saying that you never got that extra money that he's saying that he gave you?
It's not that I didn't receive the funds, so we're going based off his Zelle transactions, based off our conversations and our text messages. I have a text message back in September 24th, 2024 that we both agreed on that going forward, all Zelle transactions that have in the subject Junior, which is what we nicknamed our son, baby or child support is what's considered child support money. He said okay, and going forward is what I went based off of.
So the difference between what he's saying he's paid and what you're saying that he's paid is $3,150. So just to be clear, are you saying that you received this $3,150?
I received, yes, but those funds were for other items, personal, not having to do with our son.
And when you say personal, not to do with your son, are you saying that this extra $3,150 was for you personally?
Yes.
Okay. Pass the witness, Your Honor.
Okay, Mr. Kennedy, do you have any questions?
Hey, Ms. Rios, for what purposes were those extra $3,000 given to you?
Is there a specific date? Because I could go day by day. Just this past month, he was
Objection, non-responsive.
Ma'am, just listen to the questions and answer them, please.
sorry,
Okay. Hey, ma'am, you said that there were about $3,100 in payments that you said were not child support. And my question to you is, what were those payments for?
those payments were for reimbursements of food items, money that was owed to me that I paid for on his behalf, personal items.
Reimbursement, do you understand that when you receive child support payments, that no one's tracking behind you to see if dollar for dollar that money was spent on the child, correct? You understand that?
I understand that, but I have a separate bank account that I have recently set up for my child, so this kind of argument doesn't continue.
Well, when you get paid child support, there will be no argument because that's money that you were given because you have additional expenses because you have a child.
Correct.
And so if he was reimbursing you for food, well, actually, let's do this. Was there ever an order in place dating back to last February or March stating that he owed you child support?
No.
Okay. And so he gave you money for various reasons, correct?
Correct.
Some were directly related to y'all's son, and some were not. And so this is money, y'all were not married, right?
No, sir.
Okay, so he was not reimbursing you for any type of property settlement in a divorce case, right? He was giving you money to assist you in paying the bills for y'all's child, correct?
Incorrect.
Incorrect. What was he giving you money for?
So it like I mentioned, there would be times that I would pay for stuff that I would pay for, and then he personal items, once again not involving our son, and he would agree to pay for it back.
Okay, so he would buy items for y'all's son, or you would, or wait, who bought item? Was he reimbursing you for buying stuff for your son?
No, this is for personal items like
Like what?
food, or I don't have
And
an
who-
example.
Who was the food for?
For both of us, for
Both of us, meaning who?
me and him, or just him, or
And when you're saying him, who is him?
sorry, Gabriel, the father.
But he was giving you money to reimburse you for some of your expenses.
Correct.
Now, over the last year or more, he has had the little Gabriel every weekend. Is that correct? Incorrect. Does he have Gabriel more weekends than not?
And no, sir.
Now, again, you understand that when you get paid child support, you can use that money for whatever you want to use it for, right?
I understand.
And so you're staying by your position that he owes you that this other $3,000 had nothing at all to do with you or little Gabriel.
No, sir. Based off of, once again, relaying back to that text message that was basically a verbal agreement that we both understood going forward what would be considered child support payments, then yes.
Was that signed by a judge?
It was, no, sir.
I have no further questions at this time, Judge.
Mr. Damation, do you have any further questions of Ms. Rios?
No, Judge.
You may call your next witness.
Judge, I call Mr. Navarro. Mr. Navarro, can you state your name again for the record?
Gabriel Navarro.
Mr. Navarro, how much money for support have you given Ms. Rios since March 1st till today?
Let me get this.
Garrett, it might be, unless you're gonna introduce my exhibit, it might be easier for me to ask him that question.
I thought everyone,
The total is on the state's exhibit 1 is $10,155. Is that what you've given her, sir?
Correct.
Pass the witness, Your Honor.
Mr. Kennedy, do you have any questions for your client?
I do, Judge. The first thing I would like to do is on respondents exhibit number 1. That is a spreadsheet listing the payments that were made directly from Mr. Navarro to Ms. Rios. Mr. Navarro, that list of payments, is it a true and correct
Yes, sir.
listing of those payments?
That was directly off of Zelle.
And that was actually, those payments were made from Zelle, and when we put together that list, that was coming straight
From
from
my
Zelle
account
payments.
to her bank account. Yes, sir.
I would like to introduce respondents exhibit number 1 at this time, Judge.
Okay. Mr. Damation, do you have any legal objection to respondents exhibit number 1?
I don't object, Judge.
Ms. Rios, do you have any legal objection to respondents exhibit number 1?
No, Your Honor.
R1 is admitted.
And when Ms. Rios is saying that some of those payments had nothing to do, they were reimbursements to you or so, did you understand what she was saying?
I mean, it was for our son, food, groceries, whatever he has to eat. So it's, if they were brought, regardless, I'm supporting them.
And all those payments that are listed all went through Zelle so they can be tracked.
Yes, sir.
Okay.
Correct.
Now, how often do you have your son?
Right now, I've been having them every weekend
For how long?
ever since we weren't together.
So dating back into March of last year?
Yes, sir.
And do you have them any other times?
So every month or 2 months, me, if I don't work, or my mother, she doesn't work, she will watch them for me, or for us, for me and for Mrs. Rios. She'll watch them the whole week, or every time I'm off, I'll come by, I'll ask her, hey, can I have my son? And she allows me. So I pick him up and he'll come home with me for as long as I'm off.
And when those weekends happen, when that happens, you're 100% responsible for paying for the expenses related to your son. Is that correct?
Correct.
And you're asking the judge to take into account this additional possession time that you've had when she's calculating whether or not to order the payment of retroactive child support.
Correct.
Now, did either one of y'all, well, I guess you can't speak to her, did you have any idea what your child support would be when you started paying her directly like this?
No, sir. It's my first child, never been through this process
Okay.
before.
And so when we did the calculations, you'd actually pay about 2/3 of what would have been owed if there had been child support in place, right?
Yes, sir.
Now, and so what we were asking the judge to do is to not award any retroactive child support due to the payments that you've made and due to the extra time that you've had your son.
Correct.
I pass the witness, Judge.
Ms. Rios, do you have any questions for Mr. Navarro to answer?
Yes, Your Honor. In regards to the claim that he's Mr.
This is
Navarro's,
to him, not to me, not to any of the attorneys. It's directly to Mr. Navarro, just so you understand.
right?
So it's like
Yes.
saying, Mr. Navarro, what's the weather like today? Like that's kind of how you're asking.
The claim that there's been with our son longer than the weekends, where is this claim proven, or where is this claim based off of?
When do I have our son? You want me to say when I have him?
So I'm asking, when are you saying that you have him longer than the weekends? I understand.
Go ahead.
I understand he goes with your mom, and I take account and I notate what days he goes with your mom. That only started as of June. He was with her for a week.
Objection, Judge. I'm not hearing a question. She's testifying.
Ma'am, this isn't a chance for you to testify. It's to ask him questions.
I have no questions then.
Mr. Dehimbasian, do you have any questions for Mr. Navarro? Any follow-up questions?
Just a couple of questions, Judge. Mr. Navarro, you claim that you've had, are you claiming you've had the child every weekend?
Correct.
And, have you had the child more than a week?
Yes, sir.
Okay.
Got it.
Maybe I didn't ask the question right. How many times in the past have you had the child more than about a week?
I would say a good 4 or 5 times. The times my mom will watch him for me because I work.
So some of the possession that you've had, your mom's had possession of the child. Is that what you're saying?
I would ask her to babysit him for us. But when I'm off work, he's with me.
Well, let's do it this way to make it simpler. Have you had the child every weekend in June?
Yes, sir.
Have you had the child every weekend in May?
Yes, sir.
Have you had the child every weekend in April?
Yes, sir.
In those 3 months, have you had the child more than a week stretch?
Me, because of work? No, sir. But I've had him and I've asked my mom to babysit him.
How many days do you think the child was with Miss Rios in June?
June. I would say about 20 days.
Is that about the same in May?
June. Sorry, it's like June was more like I would less than 20 because my mom watched him for us. May, I just have to pull up the actual days my mom had him to be 100% accurate.
You don't have to be 100%. What's your best?
I would say anywhere from 15 to 20 days.
Pass the witness, Shaw.
Does anyone
I have
have
no
any
further
further
questions.
questions?
No
Mr.
further
Rios, do you
questions.
have any further questions of Mr. Navarro? Ms. Rios, do you have any further questions of Mr. Navarro?
No, Your Honor.
Mr. Dehimbasian, do you have any other witnesses?
No, Judge.
Mr. Kennedy, do you have any witnesses you'd like to call?
No, Judge.
Since Ms. Rios is representing herself and doesn't have counsel to ask her questions, I let pro se litigants have a chance to speak. Please make sure your comments are relevant to the issues at hand. And Mr. Kennedy, please feel free, and Mr. Dehimbasian, to make legal objections if you believe they're appropriate. It's a little unusual. But is there anything you'd like to say, Ms. Rios?
Yes, Your Honor. I actually I've gone out my way to try to implement a co-parenting application to keep better track of, our schedule. So as of June, I had our son for 23 days. He was with Mr. Navarro's mother, who lives an hour and a half away from here. He was under her supervision for, I'd like to say, 5 out of those 7 days that our son was with her. And then I know I had
That your person was with her? What is that?
I'm sorry, what is that?
You said 5 out of 7 days, and I thought you said that your person was with her, but I don't know what that means, and I think I misheard you.
I'm sorry. So I was with our son for 23 out of those 30 days. The 7 days he was not with me was because our son was with Mr. Navarro's mother under her. So those are the dates that he was not with me. And then in March, I don't know how far back we were going, but in the weekend, I know specifically in the weekend of March 15th and then the weekend of March 18th, as well as April 26th, he was under my custody or supervision for the entire weekend. So Mr. Navarro, not every single weekend is with our son.
Does anyone have any questions I'd like to ask Ms. Rios after her testimony?
I don't.
So
One second, Judge. No questions, Judge.
Mr. Dehmasian?
No questions, Judge.
Would anyone like to make a brief closing argument?
I would, Judge.
Okay.
With regard to the issue of retroactive child support, I would just point out that Mr. Navarro was actually in fairly substantial compliance, even though there was no order in place and neither one of them knew how to calculate the amount of child support. He paid, just based on the basis of this, 2/3 of the amount that he would have paid had he been on child support, which is quite a bit more than most people do. And so I would ask that the court find that there is no retroactive child support in this case.
Mr. Dehmasian, would you like to make a brief closing?
Yes, Judge. Judge, the state just requests that you approve the parties' agreements and that if you do order retroactive child support, then you apply the appropriate credit based on their testimony.
And Ms. Rios, is there anything, a brief closing you'd like to make?
No, Your Honor. Thank you.
I am going to render judgment. I'm going to grant and approve the agreements that were read into the record and make that the order of the court. That includes the joint managing conservatorship with the specific rights and duties that were read into the record, with Ms. Rios having the right to determine the primary residence of the child within Galveston or contiguous counties. I'm approving the parties' agreement that Mr. Navarro will have visitation and order the standard possession order with the pickup and drop-off times for the agreed 7 p.m. for both. I'm approving and ordering that Mr. Navarro provide health insurance and dental insurance through his employment, and ordering that the parties each pay 50% of the unreimbursed medical expenses. Back to the rights and duties, I'm approving the agreed to passport and travel language, with Ms. Rios maintaining the passport and the standard notice requirements for travel abroad. I'm ordering that Mr. Navarro pay to Ms. Rios the current ongoing child support of $954 per month, beginning August 1st, 2025, a month thereafter per the parties' agreement. I'm denying the request for non-disclosure, and I am going to order back child support in the amount of $3,500 and order a back child support judgment against Mr. Navarro in that amount as of today, July 21st, 2025. It will accrue interest to the family code, and I am ordering that he pay that back at a rate of $40 each month beginning August 1st, 2025, with a step up of $954 plus $40 once the child emancipates. And just, it will, as I said, will accrue interest per the family code. It is technically all due and owing, so other remedies can be used to collect that if appropriate and available. That was the request. Do you need an entry date or plan to draft now?
Judge, I'm planning on drafting them.
Thank you all for coming in, and good luck with everything forward.
Thank you, Judge.
Thank you, Your Honor.
This hearing shows how family courts often land somewhere in the middle. recognizing both a parent's financial responsibility and the real-world support they may have already provided. Instead of simply applying a formula, the judge looked at payment history, parenting time, and fairness before deciding on a reduced retroactive amount. That balance between guidelines and practical reality is something we see again and again in family law. If you want more clear, real-world breakdowns of court decisions like this, make sure you subscribe to the channel so you never miss a case update.